Dear students, welcome to UGC EPG Pathashala on Human Rights and Duties. My name is Professor YSR Murthy. I am the Executive Director for the Center for Human Rights Studies, OP Jindal Global University. In this paper on civil and political rights, today we take up the role of National Human Rights Commission with regard to the elimination of torture. Earlier on, we saw the domestic legal provisions, we saw the international legal provisions, we saw the jurisprudence evolved by the various treaty bodies. Now we take up the role of the National Human Rights Commission with regard to the elimination of torture or combating torture. At the end of this module, you will get an understanding of the powers and functions of the National Human Rights Commission in combating torture, and it will also help you to analyze the role of the Commission with regard to combating torture and its effectiveness in addressing the complaints of torture. As you are aware of, the National Human Rights Commission was established, quote unquote, better protection of human rights under the Protection of Human Rights Act 1993. According to international human law instruments as well as domestic laws, torture has been held to be a serious violation of human rights. The National Human Rights Commission has played an important role in addressing the issue of torture and mounted a multi-pronged effort. Over the years, it has made a determined effort in the direction of law reform as well as issue detailed recommendation for addressing torture. In this module, an effort has been made to lay out the broad functions of the Human Rights Commission and its role in combating torture. Now, first let us see or briefly review the functions entrusted to NHRC and also what kind of complaints mechanism exists in the Commission and its role in entirety. According to the Protection of Human Rights Act 1993, if you look at section 12, the Human Rights Commission is entrusted with a number of functions. It can inquire either suo motu or based on a petition or on direction by a court into a complaint of human rights violation or any negligence in preventing it by a public servant. It can also intervene in a pending court proceedings. It can do a number of other things, including review and report the conditions of jail, mental hospitals or other such institution where people have been held for treatment, protection and reformation. It also has a statutory responsibility to review constitutional safeguards, review laws and make recommendations for effective implementation of these safeguards. The Commission also has a role to review the international treaties and make recommendations to the government. The Commission also can conduct research, spread human rights literacy, awareness of the safeguards among the general public and other stakeholders. So, in sum, it has to walk on many legs: compliance, research, awareness generation, intervention in court proceeding, visit to institutions, etc., etc. And in pursuance of these statutory responsibilities, the Commission has been taking a number of actions with regard to the elimination of torture. If you look at the successive annual reports of the Commission, which have been published, which are available on the internet, on the Commission's website, they clearly indicate how the Commission has accorded a top priority to the issue of torture. The Commission has repeatedly highlighted the issue of torture and the need for sustained action by all concerned agencies to eliminate it. The cases of custodial violence have been duly investigated by the Commission. In addition to these individual complaints, the NHRC has also made strong recommendations for improving the legislative and institutional mechanisms to deal with the cases of torture. The role played by the Commission can be briefly summarized in a few words: redressing individual complaints of torture, advocacy for accession and ratification of relevant international conventions, advocacy for domestic law reform, generation of critical awareness among the general public, media and other sections, sensitization of police, prison officials and other crucial stakeholders, conducting training programs for key target groups, undertaking and promoting research into causes and consequences of torture and their documentation, supporting the efforts of non-governmental organizations in the fight against torture, issue instructions and guidelines from time to time on issues related to torture. This role emerges directly from its founding statute. So what did it do for the law reform? In fact, the Law Commission of India had proposed the insertion of section 114B in the Evidence Act to relax the need for government sanction in a case where prima facie charges have been established against an accused. The Human Rights Commission recommended for an early action on the suggestion of the Law Commission to the effect that section 114B must be inserted in the Indian Evidence Act 1872 to introduce a rebuttable presumption that injuries sustained by a person in police custody may be presumed to have been caused by a police officer. The NHRC also stressed that section 197 of the Criminal Procedure Code needs to be amended on the basis of the Indian Law Commission's recommendation to obviate the necessity for governmental sanction for the prosecution of a police officer where a prima facie case has been established in an inquiry conducted by a sessions judge of the commission of a custodial offence. And it is a matter of great joy that, as suggested by the National Police Commission, NHRC emphasized that there should be a mandatory inquiry by a sessions judge in each case of custodial death, rape or grievous hurt. The NHRC reiterated the recommendations made by the Law Commission of India. So pursuant to the NHRC's efforts, necessary changes in the law have been made by the government. Now let us look at what NHRC did with regard to the international convention. The need for India to accede to the Torture Convention 1984 was first raised by the Human Rights Commission in the year 94-95. To deal with all the arguments and objections that had been raised in this regard, the Commission presented a comprehensive memorandum to the then Prime Minister on this subject in April 97. That analysis, it's a very critical, in-depth analysis, contributed in large measure to India signing the UN Torture Convention on 14th October 1997. The NHRC urged the earliest ratification of this key convention and the fulfillment of the promise made at the time of signature, namely that India would, I quote, uphold the greatest values of Indian civilization and our policy to work with other members of the international community to promote and protect human rights, unquote. Ratification, however, is still awaited despite the repeated appeals of the Commission. Now let us look at how NHRC handles individual complaints of torture. Custodial violence and death in the police lockup as a result of torture strike a blow at the rule of law, which demands that the power of executive should not only be derived from law but also that it be limited by law. The custodial violence is a naked violation of human dignity and degradation which destroys to a large measure the individual personality. It is a calculated assault on human dignity which no civilized state can tolerate. The curbing of custodial violence has, therefore, been a major objective of the NHRC ever since it was established. According to Section 18C of the Protection of Human Rights Act 1993, the NHRC has the following power. It can recommend to the concerned government or authority at any stage of the inquiry for the grant of such immediate interim relief to the victim or the members of his family as the Commission may consider necessary. Therefore, in case of death of a person during police custody, the Commission is empowered to issue a show cause notice to the state machinery which is responsible as to why the deceased should not be granted an immediate relief. As a part of the efforts of the Commission, it has compelled the payment of compensation to the victims of deceased, to the next to the kin of deceased. In one of the cases, the view of the Commission was expressed in the following words, I quote, "State is vicariously liable for the death of the under trial prisoner, and if the death of the deceased was due to the negligence on the part of jail authorities, state had to pay a sum reasonable to the next of kin of the deceased under Section 18(3) of the Protection of Human Rights Act," unquote. The Commission has taken cases of police harassment also very seriously. In the view of the Commission, the primary job of the law enforcement officials is to ensure that they serve the public as per the legal boundaries, within the legal boundaries. At no point can the police official or the state machinery be allowed to act outside the boundary of law. The Commission has said the following words with regard to its responsibility of ensuring proper compensation in case of police harassment, which is a form of torture. It said, the object of section 18(3) of the Protection of Human Rights Act is to provide immediate interim relief in a case where a strong prima facie case of violation of human rights has been made out, so that the complainant is provided immediate relief, which need not await, which need not wait for the determination in another proceeding of the full compensation awardable or identification of the particular public servant guilty of the violation and determination of his liability in another proceeding. A welfare state, recognizing its obligation to afford relief to its citizens in distress, particularly those who are victims of violation of their human rights by public servants, has made this law under which government seeks advice from the NHRC as to what, in this view, is reasonable immediate interim relief, so that the state can act on the recommendation. The meaning to be given to the section 18(3) of the Protection of Human Rights Act by any state professing to be welfare state should ensure a liberal construction to promote the philosophy of the statute and to advance its beneficent and benevolent purposes. The NHRC, having been constituted under the 1993 Act for better protection of human rights and civil liberties of the citizen, has not only the jurisdiction but also an obligation to grant relief in appropriate cases to the victims or the next of kin of the victims whose right to life under Article 21 of the Constitution has been flagrantly infringed or violated by the state functionaries, by calling upon the state to repair the damage done by its officers to the human rights of the citizen. The state, in all such cases, is vicariously liable for the wrongful acts of its officers. When the state is called upon to grant monetary relief to the next of kin of the deceased or the victims of torture, as the case may be, by the Commission, it is because the doctrine of strict liability of duty of care on the part of the state is attracted to such cases. The state is vicariously responsible if the person in the custody of the police is deprived of his life, except according to the procedure established by law, and to recompense the heirs of the victims. Now let's look at some individual case studies. There is a certain Rakesh Kumar Vij in Uttar Pradesh. What are the facts of this case? In connection with a murder investigation, the Uttar Pradesh police had illegally detained Rakesh Vij. He was ill-treated, tortured, electric shocks were administered to him by making him urinate on a live electric coil in order to elicit information from him about a murder. He was also not allowed to meet any family member. This torture had totally incapacitated Rakesh Vij and led to his hospitalization. The report from Senior Superintendent of Police Varanasi stated that while trying to run away from police custody, Rakesh Vij fell and sustained injuries. And the report also stated that he had a criminal record. The Uttar Pradesh Medical Board in its report claimed that victim did not suffer from any gross structural damage. Most of his complaints were subjective. The patient had made a good recovery and that all his medical test results were within normal limits. Not satisfied by this report, the Commission sought some second opinion. The Delhi Trauma and Rehabilitation Center gave an entirely different assessment. All India Medical Institute of Sciences, AIIMS, in its report stated that the victim's spinal cord was compressed, leading to deterioration of power in his lower limbs, sensory loss of bladder and bowel movement. There were 60 to 80% chances for improvement, but only if the victim undertook a high-risk surgery. He was suffering from hearing loss and some of his teeth were missing. He was suffering from severe post-traumatic stress disorder with no proven treatment. Having regard to these reports, the Commission recommended the Uttar Pradesh government to pay Mr. Rakesh Vij a sum of rupees 10 lakhs by way of immediate interim relief, arrange for the complete medical treatment, prosecution of the police officers responsible for his ill treatment, and action against doctors for giving an incorrect, inaccurate report, and findings about the status of health and extent of his physical disability and incapability suffered. Now let us look at second case, death of Sher Mohammad in police custody by torture, again in Uttar Pradesh. But this kind of cases, examples can be replicated and can be found in other states as well. The Superintendent of Police, Badaun, UP, vide his letter dated 23rd February 1996, intimated the NHRC about the death of Sher Mohammad, son of Abdul Rashid, an under trial prisoner who was arrested on 22nd February 1996 in a case under Arms Act and in a case under section 364 of the Indian Penal Code by the police from Binowar police station. It was reported that the under trial Sher Mohammad fell ill and he died while on the way to District Hospital Badaun on 23rd February 1996. In response to the notice issued by the NHRC, the post-mortem report, the magisterial inquiry report, was sent to the Commission. And a review of the magisterial inquiry report showed that the said under trial prisoner was beaten up by the station house officer while being interrogated in the two cases registered against him and died as a result of police torture. A criminal case was registered against the station house officer and a charge sheet was filed in a court under section 302/323 of the Indian Penal Code. While considering the matter on 14 January 2004, the NHRC agreed with the magisterial inquiry that it was a case of custodial death which was caused as a result of severe beating of the under trial while in custody of the police. The Commission therefore directed the issuance of notice to the Chief Secretary, Government of UP, to show cause why immediate interim relief of rupees 1 lakh under section 18(3) of the Protection of Human Rights Act be not given to the next of kin of the deceased. The Commission also observed that death in police custody is one of the worst kind of crimes in a civilized society governed by the rule of law and poses a serious threat to an orderly civilized society. Torture in custody flouts the basic rights of the citizens and is an affront to human dignity. Police excesses and torture in custody of the detainees, under trial prisoners or suspects, tarnishes the image of a civilized nation, and it is necessary to take stern measures to check this malady. The Government of UP submitted its compliance report in respect of the payment of rupees 1 lakh to the next of kin of the deceased. Now let's turn our attention to one more case study, death of Sri Kantosh Prahlad Jadhav in police custody by torture in Latur, Maharashtra. The commission received an intimation dated 28 October 1995 from the District Superintendent of Police, Latur, Maharashtra, stating that one Kantosh Prahlad Jadhav, aged 22 years, was arrested on 28 October 1995 in police station MIDC, Latur, under section 324, 504 IPC and 135 of the Bombay Police Act. He had further stated that the accused, while in custody, committed suicide by hanging himself to the iron rod of the ventilator of the police lockup with the help of torn part of a blanket provided to him. In response to the Commission's notice dated 3rd November 1995, the inquest report received showed no signs of beating either on the front side or back side of the body. The report further said, postmortem report indicated no external or internal injuries on the body of the deceased, and the cause of death was opined as asphyxia due to hanging. The subdivisional magistrate, in his inquiry report, concluded that on the basis of statements of witnesses and on examination of the postmortem report, the death of the Kantosh was due to suicide committed by him by hanging. However, he observed that there were other factors also, such as negligence and lack of responsibility on the part of police officials, which resulted in the incident. The government of Maharashtra submitted an action taken report on the magisterial inquiry, which indicated that the accused police officials were placed under suspension and departmental inquiry had been instituted against the delinquent officials. The Commission, vide its proceedings dated 2nd August 2004, while considering the magisterial inquiry report and the department action taken against the police officials, directed the Chief Secretary, Government of Maharashtra, to show cause why interim relief should not be paid to the next of kin of the deceased. In response, the Home Department, Government of Maharashtra, vide its letter dated 7th October 2004, informed the NHRC that the state government has decided to grant relief of rupees 50,000 to the next of kin of the deceased Kantosh Prahlad Jadhav, and after obtaining approval of the Commission, further action for disbursement of relief will be taken. The Commission, in its further proceedings, considered the case and approved the grant of rupees 50,000 as interim relief to be paid to the next of kin of the deceased Kantosh Prahlad Jadhav. If you see NHRC annual reports, you will find many such case studies. There is one case where Kerala government was asked to pay a sum of rupees 10 lakhs to ISRO scientist Nambi Narayan, who was a victim of illegal detention and torture and allegations of being a foreign spy. Yet in another case, 5 lakh rupees monetary relief was awarded in a case of death in custody of Jammu and Kashmir police of Mohan Lal, a rickshaw puller. The NHRC has one more role of issuing guidelines and instructions. Police and public order are state subjects under the 7th schedule of the Indian Constitution, and it is primarily the responsibility of the state or the UT government to prevent and ensure non-recurrence of custodial violence. However, The NHRC also issues guidelines and instructions from time to time. The NHRC, immediately after its establishment or constitution in 1993, condemned the violence in police and judicial custody. It observed that violence, whether in police or judicial custody, was a matter of gravest concern to all who believe in human rights, and rendered it as absolutely unacceptable. As early as 14 December 1993, within a couple of months of the Commission's establishment, the NHRC instructed all Chief Secretaries to ensure that all cases of custodial death and rape must be reported to it within 24 hours of occurrence, failing which an adverse inference would be drawn by the Commission. On 10th August 1995, all Chief Ministers were requested to ensure that all post-mortem examinations of deaths in custody be videographed. On 27 March 1997, CMs were asked to adopt a model autopsy form prepared by the NHRC and to use for this purpose. The Commission had issued revised instructions dated 3rd January 2001 to all Home Secretaries for sending following information. 1. The post-mortem report in new pro forma circulated by NHRC in March 1977, along with the videograph and the magisterial inquiry report, must be sent within 2 months of the incident. 2. The post-mortem report and other documents should be sent to the Commission without waiting for the Visira report. The Visira report should be sent subsequently as soon as it is received. Now, let's recall or briefly summarize the various important instructions and guidelines on torture issued by NHRC. It has given guidelines on medical examination of prisoners on admission to jail. It has given guideline on death during the course of police action, given detailed reporting requirements on custodial deaths, rapes, on cases of encounter deaths. It has issued guidelines on visits to police lockups and also polygraph tests, and guidelines on arrests were also given. It has given a detailed guidelines on human rights in prisons. NHRC also circulated instructions issued by the Supreme Court of India in D.K. Basu's case to all states for strict compliance and wide dissemination. To conclude, the NHRC has taken a range of actions to combat torture and to prevent custodial violence. Thank you.